So first, Ken, I want to thank you guys for inviting us to this. We need to do whatever we can to make sure that anybody that's impacted by a Rett syndrome, that their families are aware of the services that are out there that we can utilize. So my role is I'm the president of the Ontario Rett Syndrome Association. We're a small non-for-profit in Ontario that services pretty much the entire country. We do work for individuals with Rett syndrome. It's a rare neurodevelopmental condition that's caused by a mutation in a gene. Individuals that have Rett syndrome will develop normally from about 0 to 6 to 9 months, and then they'll start to show some regressions. A lot of them will lose the ability to walk, lose the ability to talk. If their fine motor skills will decrease, gross motor skills as well. A lot of individuals will develop scoliosis, a heart condition, seizures. So it's a pretty impactful disease. That being said, on the bright side, there's a lot of great work being done throughout the world, and especially in Canada on Rett syndrome research. And I mean, we're very hopeful that the funding that we're doing and the funding that other people are doing for research, that within the next few years, there's going to be some significant progress in improving these people's lives. So that's kind of who I am and what we do. I'm looking forward to working with you guys, Ken. We have a conference coming up in May of 2020 in London, Ontario, where we bring in doctors, researchers, and we have them interacting with the families. And we get great feedback on that style of conference. So I say we're a small association, but we're a pretty mighty association when we put our mind to it and get stuff done. So,
well, I was just commenting that the last time I was a speaker at your conference was 10 years ago.
Yeah.
I forget where that was. Was that London? I forget. I don't know.
I could have been. We usually rotate like Southwest, Central Ontario, and then Northern Ontario. So we're back in London in 2020. So, and we look forward to your participation.
And this is the Rett Syndrome Month.
It is. October is Rett Syndrome Awareness Month. October 29th is Rett Syndrome Awareness Day. Our goal as an association is to light the province up purple on that day. Lots of people's households will have purple light bulbs. The CN Tower will be purple. The Toronto 3D sign will be purple. Niagara Falls will be purple. The city of Guelph is going purple. London, Ontario is going purple. So I'd love to have a Google shot from above the earth of Ontario on October 29th and hopefully see a little bit of purple everywhere.
That'd be great, eh?
Yeah, absolutely.
Well, that's good. Thanks, Kevin. I appreciate that. You're welcome to continue to listen in or come back from time to time, take part later if you wish.
I'm probably going to mute myself because I'm just walking into a ORSA fundraiser pink night. So I'm no artist by any stretch, but we'll see what it looks like when we're done.
Okay, good luck.
Awesome. Thank you, Ken. Thanks for doing this and having us. I appreciate it.
Take care. So I have a bunch of questions, and that's just great. What happens, the reason that we did this particular one is, of course, we answer questions and solve problems all day. We get all sorts of calls and emails and chat box and, all sorts of things. But what's been happening is that we've been making the monthly webcasts, and we've done several of the annual updates, to bring people current. And that's, we have, standardized PowerPoint slides and so on. And you're welcome to any of those, anybody who's taken part. We've got, what we got here now? 42, that's probably what we'll get. It's 10 after. Other sessions we've had 400 or 500 people register. And that's not uncommon. We have a 10,000 person newsletter list, which covers all of our clients and family members and financial advisors and specialists and so on. So we usually get a pretty good turnout. But you know, obviously 400 to 500 don't take part. Anyone who's ever registered for a free webcast knows that you don't always take part. So I'm happy to talk to the 42 of you because what happens with the other sessions with so many more people is that we don't really get a chance to answer the questions. So what we're doing is we're putting out information that's valuable, but we're putting it out because we think it's something that you'll want to know, which I trust it is. But we also find that, because of course we know who registers and who takes part and who repeatedly registers, either because they couldn't take part or because they want to take part another time, which is very common. So obviously people aren't getting all their questions answered. So I thought, well, let's just do a question and answer and we'll spend maybe an hour. We have questions that were sent in advance, so I'm going to look at those first. If anybody's having any technical difficulties, you can call the office and you can go to extension 105, just punch in 105, and Karen will help you with the technical problems. It's 866 Ken Pope, 866-536-7673. And, you know, frankly, I hate it when anybody else does that. But years ago I did, I couldn't resist. So 866 Ken Pope. So the first question, the big question, and this is a common question, it's a very common question, is people go to the ODSP website and they look at what they feel is roughly the most recent information, which it is because the rules changed on September 1st, 2017. And as you know, the gift rule changed from $6,000 over 12 months to $10,000. So people can receive $10,000 into their own hands for any purpose. Now, there's a whole lot of situations where, you know, the adult children are not given $10,000, either because the parents don't have it, or more often the fact that, you know, the parents use the money to buy stuff for the kids. Now, of course, that $10,000 that the parents spend for the kids, of course, that's not taken into account, is it? While the parents are alive. You know, it's only money that goes into a trackable account. So, you know, if you have the common procedure where you transfer a certain amount of money, not typically $800 a month, $9,600 over 12 months, not typically that kind of money, but it happens. And you put it in the child's account, well, it's accountable, trackable, and in due course, it's supposed to be reported. Now, it's all just fine, of course, because it is just fine. So if you don't happen to report it, which is, you know, theoretically, you're supposed to report each month on the stub how much the child receives. Well, if you don't report it and it comes to ODSP's attention, it's fine, so that's fine. If you have a mechanism, which many people do, for the child to receive a set amount every month, if you tell ODSP once or twice, if they don't catch it, that this is the amount monthly, they'll put it on the record and it's duly reported forever. You know, if you change the amount from 300 to 500, well, I guess you should tell them. But it's all good because it's less than 800 or 9,600 or 10,000 over 12. The other main change was the asset test. It was comical. The asset test was $5,000. Was increased to 40,000, which is, you know, a reasonable amount for a person to have. Lots of people, lots of working people, young working people, don't have 40,000 sitting in the bank. So why would a person on ODSP have 40,000 sitting in the bank? But of course, we do have lots of clients whose children inherit money, come into money, get gifted money, you know. The confusion that comes up is that the rules say that the child can receive $10,000 over 12 months. That's true. But they can also receive $40,000 and have it. So, for example, if you wanted to give the child 35, this is uncommon, obviously, but if you wanted to give the child 35,000 less than 40,000, once received, they can keep it. And once received, it's fine. And once received, they can spend it on anything they want, above and beyond the 10,000. So that's pretty simple. So you can see also that if you pass on and you have a trust set up for your child, one thing you could do, although again, this is not common, is you could simply give the child periodically $35,000 to stick in the bank. They could then spend it on whatever, rent, food, alternative therapies, insurance for the car, travel to Cuba, anything, once received. It's the receiving part that's the problem. So they can have 40, they can only receive 10 over 12. So the 10 over 12 is great, that's in addition to the 40. But what this means is that if they receive 40, 35 say, that's in excess of the 10, and in the month received, they have been overpaid their amount of ODSP, whatever that is. So if they're at home with their parents, and they're getting $896, which of course is the lesser amount, 15% of the children are at home with the parents and receiving the lesser amount, $896. So of course we fix that on a regular basis, on a daily basis actually. But or if they're receiving $1169, the full amount, then that month in which they received the $40,000, they were overpaid. So the overpayment is put on their monthly stub, and their benefits are reduced by $50 a month. And in 22 months, they have repaid $1169. And you know, if you wanted your child to live in the style to which they would love to be accustomed, and to give them chunks of money twice a year, well, in those 2 months, they would be overpaid. The amount that they receive, $1169, $896, but the $50 stays the same. So you could certainly have an accumulating overpayment, but continuing $50 a month clawback. And of course, if the child happens to be receiving CPP disability of 700, and then the difference of ODSP, well, it's only technically 5% of what they receive. So when I say $50, I'm saying 5% of $1169 roughly, but it's normally like $50. But if they only get $200 or $300, it would only be 5% of $300. So that's fairly clear. So what happens with the trust? This is the real question here. Is, well, I tell you that the amount of money that can be dispersed from the Henson Trust, which can have an unlimited amount of money, is unlimited. And then people say, well, I went to the website, God bless you, not my website, the ODSP website, God bless you, to look for information, and you're hesitant to contact ODSP. How do you explain this discrepancy? Well, there is no discrepancy, because the disbursements from the trust, just like from the parent, are unlimited. But yes, if those amounts are paid to the child or for the child and reported annually in the annual report, well then yes, if you have in a single month come up with a budget to prepay the part of the rent for the year for their apartment that they can't pay, and you've always paid and now you're deceased, let's say $700 a month. So you disperse $8,400 by giving it to the property manager to use to defray the rent for the next 12 months. Or you could make it double that for 24 months, triple that for 3 years if they're going to be there for 3 years and you know they are. And in that 1 month that you have prepaid the property manager, $8,400 or times 2 or times 3, well, yes, there was a 1 month overpayment. So what you do is you, the trustees, come up with a budget, and it could be any size. Now, of course, the the size of the trusts are not usually huge. We have some $1 million trusts generating $50,000 a year, which the family wants to be spent on the child, and they can live in style to which they wish to be accustomed. Most of these trusts are to 100, 200, 300, 400, and they're often invested conservatively. Trustees don't want to lose the money left by their parents, so they're invested at 3%, perhaps 4%. So on 300,000, it generates, let's say, $9,000. Well, you know, that child may live within that budget, and that 9,000 is less than 10,000. So obviously, there's just no issue here. So when this question comes up, well, you say that they can have anything or any amount. That is true, but of course, we're still living within reality here. What are the options other than segregated funds for investments within an RDSP? Well, that depends on where it's invested, who it's with. If it's with a bank, it's usually whatever's on offer at the bank, GICs, mutual funds. But you know, if you were with TD Waterhouse, self-directed, the sky's the limit. So it's really a matter of what's available, where the funds are being invested. If you're with any of the banks, you have a reasonably restricted investment portfolio option. There's nothing wrong with them. But if you're with some of the other investors group, for example, or Mackenzie Financial, TD Waterhouse, you can, in fact, go to the maximum spread. I remember one time, a few years ago, my dad was investing in oil stocks. Now, of course, you wouldn't do that right now, but at the time he was, and he was doing extremely well. Getting, 18, 20% return. Who should be the beneficiary of an RDSP? RDSPs do not provide for beneficiaries. They're not insurance, they're not seg funds, they're not TFSAs. RDSPs don't have designations. So they fall into the estate of the beneficiary, the child, it's the child's property. And if the child passes on, they fall into his estate and are either distributed by his will or by succession law, which means if the parents who, in fact, contributed the money survive the child, and we've had a few files like this, then the parental contributions plus, as of this year, 1 year's worth of vested grants and bonds would fall into the estate of the child and then pass by succession law to the parents. The parents are predeceased. If the child has siblings, it goes to the siblings. If they've predeceased and they left children, it goes to their children. If they have no siblings, then it goes up the ladder and over and down and eventually could land in the pocket of the cousins. But that's succession law. You can Google succession law Ontario and it'll tell you exactly who would get it. Because of course, a large number of people who by definition are approved for the disability credit are not mentally competent and can't do a will. And no, a legal guardian can't do a will for the child. When a person with a business starts up a small business, how does this affect ODSP? Well, if the ODSP recipient is the business person, it's complicated because ODSP doesn't really get it as far as business. I remember one client down the street here in Ottawa where he was running a shawarma shop. He and his family were on ODSP because his wife had cancer. And ODSP disqualified the expense of his parking spot. So he explained to them, well, you know, if I run on this stuff, I have to go to Costco and get some. You know, I have to have the car with me so to do this. But they, you know, they feel their job is to say no, of course, first. And of course, none of them have ever been self-employed or self-sufficient, probably. It's comical. We have about 80 ODSP workers in Ottawa. I'm not sure how many there are in the province. Lots of them. In Ottawa, my understanding last time I checked was of the 80, all but one were females. And of course, that's why we get such a sympathetic, considerate, supportive, informational amount of help from the local ODSP staff, because they're women and they care. Looking for Henson Trust information, can you discuss? No. If you put a house in an ODSP recipient's name, would this affect the amount they get? No, you can. People can own a house. They just can't carry it, because of course their shelter component for an individual is $496 a month, and you can't carry a house on $496 a month. But you could put it in their name. The parents could subsidize it. If they did, those payments made for the shelter costs are deemed to be money given to the child, and so they're you know, you have to work it around the budget because it would normally exceed the $10,000 over 12-month rule. That house, of course, in their own name, it's not common. I've only seen it 3 times since '96, but it would qualify as a principal residence. It's capital gains tax free. If they married, it would be a principal residence, a matrimonial home, and divisible in the case of divorce. And of course, the child wouldn't qualify for a mortgage. So what happens is the parents guarantee the mortgage, and then the parents die, and the bank won't renew the mortgage. So it's fraught with concern. What is the best way to structure a will for the benefit of the disabled individual? Well, that's why I brought you to my website and the video page. And you can see there's, I think, 29 videos. They're all under 3 minutes. And here is the Hanson Trust video. So that's the place for you to go to get that answer. What evidence of disability does Ontario Teachers' Pension Plan require for disabled adult son? That's a good question. Because teachers' pensions, OMERS pensions, municipal employees, and power generator hydro pensions, they're all provincial statutory pensions. And by statute, there's a pension for the retiring party. If they have a spouse, if the retiree passes on, there's a pension for the spouse. If not, there is still a pension for the child. Now, they have to be an adult dependent survivor. Now, the issue of evidence of disability, I would say that if your child is approved for the disability tax credit, then they're markedly restricted. So I think you're good. And if they're on ODSP, they can't function in a competitive workplace or in the community or handle personal care. So I would say that that would qualify as well. Now, the form actually has to be completed by your doctor initially, but more importantly by their doctor. And the decision of what is the disability would be determined at that time. So if you happen to have a child who's really on the cusp, and there's the question of do they have a disability? If you have a child, for example, with Asperger's syndrome, who is in university and finishing various programs, they have Asperger's, they qualify for ODSP at that point. So, you know, there are things to establish, but I don't see this as being much of an issue. Is it too late to arrange for a Hanson Trust when my daughter turns 18? And what are the benefits for a Hanson Trust? Well, again, that video and the age of the child has nothing to do with anything. It all kicks in when the parents pass on, typically upon the second death. Can a person receiving ODSP put a Hanson Trust in place and choose the trust? No. It has to be in the parent's will. And it is true that if the child receives an inheritance, we have various ways to try to protect ODSP benefits. We can certainly protect the first 100,000, and we have ways to do much larger sums. But it's not a Hanson Trust. One of the possibilities is the child setting up their own inheritance trust and appointing a trustee to manage the money for them if this is appropriate. I'm looking to talk about powers of attorney, why we should get them. Well, when you have a child who's turned 18, if they're competent to sign powers of attorney, you should put them in place because they're competent. And it's just inevitable that one of these days you're going to be dealing with doctors and hospitals, and they will decline to give you information, privacy legislation, all of that. Doctors and hospitals tend to think they know best, but they still go on the triage system. You know, the group can't fix you, we can fix you, maybe we can fix you. So they allocate resources. And the problem is that it's difficult for anybody, but it's especially difficult for people with disabilities and their families, and for older people, senior citizens and their families, because there's no question in the medical system, I think based upon the triage system, it's not that the medical system doesn't like people with disabilities or old people. They just have a bias against them. So, you know, if you're a broken bicycle, why fix the tires? I remember one dad, his daughter was in her teens and she had scoliosis. And it was starting to affect her breathing because she was tipping over, you know, to the side. And this is current, this is just some few years ago. And so the dad, these things, you have to laugh at these things, otherwise you get cynical. The dad went to the girl's doctor, you know, dealing with the scoliosis. And I don't believe it. I mean, I know the story is true, but I don't believe it. The doctor said, well, she'll just have to get used to it. So of course, what the dad did was he took the daughter to a different hospital. I believe it was the Shriners in Montreal, and arranged to get the operation, because the operations are great. You know, a great buddy of mine, a really close buddy of mine, was scoliosis correction operation number 2. He's my age, roughly, a little bit younger, not much, but I'm 67, so maybe 64, 65. But he was scoliosis operation number 2, and he was in a body cast for, I don't know, 6 or 12 months in the hospital for the longest time, and then in bed at home. And the last time I checked, somebody told me that it took basically 3 or 4 days now to to do the operation and release you. And I mean, I'm sure there's still, casts and braces and all those things, but that is the root. There's always going to be somebody who really doesn't give a damn about your kid, and you got to fix that, obviously. And if you have powers of attorney for personal care and property, they at least have to disclose information and listen to you. And if you can just recite the term informed consent, and Ken Pope, lawyer, people listen a little bit more. So that's why you need powers of attorney. And if not, then you should have a serious discussion about legal guardianship. Can I transfer my parents, the parent RRSP to my son's RDSP upon my passing? Yes, up to a limit of $170,000. Now, of course, you'd have to have a scenario where you take into account the fact that this means that it's now the child's money. Can they manage it as an investment? When they die, will they have a will? That kind of thing. Has the difficulty of being approved on ODSP increased over the past months? No, I don't think so. Well, that's based upon our experience. I'm just trying to think. I'll have to ask Crystal whether we have ever not succeeded. I guess there must be times we haven't succeeded. But I wouldn't say it has gotten harder for us. Whether there's been more obstruction for families, I don't know. The test is still the same. The test hasn't changed. There was talk about making the test the same as CPP disability, which is that you can't work at all. But that's not the test. The test is can't function in a competitive workplace, can't function in the community, can't handle personal care. And, if your child can't do those things and you properly document the material, I haven't found it to be more difficult, but you could ask Crystal, she would know more than me. Obtaining guardianship prior to PGT involvement. Public guardian doesn't want to get involved with your child. And if legal guardianship is not in place for you, then if the child is found not competent, well then yes, public guardian is brought into the picture. They become the statutory guardian, and you then have to seek permission from the public guardian to take over as statutory guardian. So yes, it's true that if you had applied for legal guardianship prior to any involvement by the public guardian, well then the issue would be settled. There would be no question about assessing the child and finding them not competent and putting that certificate of non-competence on the public guardian's desk, because of course you're the legal guardian, they've been found not competent, right? It's not an issue. So if it's a preemptive thing, then yes, you could certainly do that. But the typical involvement of the PGT, it's not a day-to-day problem. And they don't want to be the statutory guardian. They're not looking for work. I have 2 disabled sons. Need help determining the amount to be paid to avoid loss of ODSP. I don't understand clearly. But if they each receive $11.69 and they are paid $11.69 or more, well, then they would lose ODSP. Now, it's not quite that simple because, of course, under the present rules, first 200 is exempt. And then from there, for every dollar they make, they lose 50 cents of ODSP. So it's not really $11.69, but if you go through the formula, 200 and then offset 50% for every dollar, that's basically twice $11.69, roughly. Do I need to qualify for the Henson Trust for receiving inheritance from my parents? You don't have to qualify, but Henson Trust would protect your benefits. You've obviously typed a question here, so the odds are you may well be competent. But that doesn't change the fact that you still have to have it managed by a trustee in order to not have it as a liquid asset, which would disqualify you. You can't be your own sole trustee. I've only done this twice, but you could be potentially a joint trustee. I'm not sure just what that really does for you, but you could. How can I protect my benefits if the beneficiary receives a direct inheritance from my parents that is not an Hanson Trust? Well, we deal with this on a daily basis. Demographically, people are getting older all the time, passing on. It's not going to decrease. The children of the boomers are going to increasingly come into this scenario, obviously. We have ways of protecting those inheritances that are not in Henson Trusts. There's some simple ways. There's some more complicated ways. And really, it's a matter of when you come into that inheritance, if your parents have not set up a Hanson Trust, give us a call and we'll fix it. Or if you like, we'll talk to them and say, well, here's what you should do. But, you know, if reading between the lines on this question, if it just appears unlikely that the parents are going to do a Henson Trust, they're not going to do it. You just have to live with that and fix it afterwards. Difference between guardianship and power of attorney. Power of attorney is something, power or authority given by a competent person, which can be revoked, whereas legal guardianship is granted by the court after someone has been had a capacity assessment and found to be not competent. I have 2 adult children. What if our non-disabled child is reluctant to become substitute decision maker? Very common. Well, then you have to think about it hard and come up with alternatives. And maybe those alternatives are available now, and maybe they're not. You might be able to look eventually at cousins, perhaps. But it's an issue because families are increasingly smaller. Perfectly understandable that you have 2 kids. The other child grew up with their sibling. That child always got all the attention, and also they're a pain in the backside, right? Not only do they have disabilities, but they're really not that nice a person. You know, they've been catered to. They know how to pull their parents' strings and push the buttons. You know, you just don't want any part of it, you know, perfectly understandable. Well, it's awkward. We need to talk about that. How do you manage multiple Henson trusts from different wills for the same beneficiary? Oh, well, you just coordinate them. If you have different trustees, you convene a bit of a meeting, decide as trustees whether you're going to share things or whether you're going to leave it firstly to, let's just say, the grandparents' trust and then the parents' trust. Maybe there's a trust set up by an aunt, never married, no kids, really like that child. You know, so you just have to get together and discuss it. So those are all those questions. Let's see what we got here. It's 7:45. I'll go as long as my voice holds out. We have 42 participants, so everybody seems to be holding fast. I'm going to take a look at it at 8 and at 8:15 and just see whether I can keep talking. I spend a lot of time talking during the day, so by the time it gets to the evening, I need my tea. Are there professionals available for administering a Hanson trust? How much do they charge? For estates under 200 or up to 500? How about 1 million? That's a good question. Well, all the bank trust companies, all banks have trust companies that they own. And those trust companies will be trustees for you. But as a rule, these days, they don't really want to be a trustee if the trust is less than about $500,000. So if you determine that the trust in your will is going to be 200 or 300,000, and you just gratuitously go ahead and name a trust company, that doesn't mean that they will accept the trust, which leaves a problem. There is one, and their fees, unless you have some kind of sweetheart arrangement where you used to work for the Bank of Nova Scotia, or you know, some arrangement where you get some preferred rate, then standard fees are 1.5% per year. So it's not that great actually, or that expensive, because on 300,000 it would be 4,500 a year. It's just not bad. It's 300 a month. Now, if you've got 300,000, you can certainly invest it at 3% and get 9,000, and you're paying 4,500. So you're paying 4,500, half of 9,000 for trustees' fees, and you have 4,500 left for the beneficiary. And that's unfortunate in a sense, but if the trust company is the only last and best choice, it's your last and best choice. If you were to retain a lawyer or an accountant or a financial professional who was not managing your investments, because the advisor can't be both your advisor receiving compensation and trustee, because it's not sufficiently arm's length. But if you had an advisor of some sort who wasn't managing your money, then they would probably ask for the same fees. Now these trusts are working their way up towards 500,000, but majority are not 500,000. And I think what's happened is, of course, all of the financial investment houses and trust companies and all that, they're trying to focus on high net worth clients. And then what happened was a few years ago, largely in Ontario, the regulatory organizations are trying to move financial advisors and investment houses away from commissions and back-end fees in the name of transparency and openness and disclosure and all that. Well, if that's going to happen, and if it's inevitable, well, then you have to shift over to a, excuse me, a fee-for-service arrangement where you get a percentage of the assets under management rather than a commission on placing and moving and selling and buying stocks and things like that. So the investment houses all started to consolidate. They started to let go of their advisors that had lesser clientele and started shooting more for high net worth, even more. And the problem is that what we saw in Australia and the UK is that approximately a third of the advisors left the business because they couldn't accumulate clients that had high net worth, which meant that all the people who weren't high net worth weren't getting advice. They weren't being having proper discussions about life insurance to provide for your spouse when you're gone, and proper use of RRSPs and the advantages of TFSAs compared to RRSPs for people in a lower tax bracket. I mean, obviously RRSPs are stupid for people in a low bracket because as you're older, you're not going to really, it's just a deferral. And if you happen to die with a lump sum RRSP, you pay more than you would have paid if you just paid it to start with and saved it. So, you know, the average run-of-the-mill people, which is like 75% of the population, 75% of the population in Canada that files a tax return, files a return saying that they earn $50,000 or less. I would say most of those people are not high net worth clients. I think they deserve advice. I think they should have somebody nice who comes to their home and without too much pressure explains universal life and joint and last coverage to fund the trust for the child with disabilities. I think that's a good thing. So anyway, I rambled a bit. So what's happened is the trust companies all up their ante. They always wanted big trust. It's just then now they said, well, we're only going to do big trusts. So the firm that I recommend in this case is, unless you can find an appropriate professional who will take the smaller trust, is Concentra Trust. CONCENTRA, Concentra Trust. And firstly, they charge 1%, not 1.5. They're owned by some big credit unions out west. They have billions under management. Been at it for decades. They're based in Saskatoon. And they will accept small trusts, which is why I refer clients to them. So if you have a $300,000 trust at a 1% annual fee, that's $3,000. That's, I think, it's very economical. And if you happen to have a $200,000 trust, they will still charge $3,000. That's their minimum. But again, they will be the trustee, which is what you want. It's not so much whether you're paying $2,000 or $3,000. That's not it. Because by the time you get to Concentra or Royal Trust or Canada Trust, they're the last best choice. Okay. How many hours a year is involved for a family member to administer a trust? This would involve yearly disbursements and possibly the family home the disabled person resides in. Can't really tell. You can put a lot of things up on automatic payment. From a practical perspective, the family home is a rarity. It does happen, but the family home is a rarity in the sense that it's too big and costs too much. This then gets you into a discussion about a condo or an apartment. And of course, you can always hire cleaning staff to come in. You can hire people to make food, bring in food. So you can clean the place, provide food. You can get a property manager to make sure the toilet's fixed. You know, you can hire a personal support worker. You can hire a friend for 20 or 30 bucks an hour to come in and check on the child however many hours a week you want. And you can also still try to get a certain amount of support, as it used to be anyway, from the Community Care Access Center. As far as I know, passport funding is still available to family members, whether they're trustees or not, to give them respite if they're taking care of the person. Even if they're the trustee, they're still the brother. So, you know, if anybody knows better than me, let me know, but I don't see why passport funding wouldn't be available for that. You could use that to pay the social worker, the personal support worker. I received a lump sum from CPT, and the government is unwilling to adjust my returns to attribute the income over 3 years, since the tax owing would be identical in either case, except that I would get my DTC for the years back, which I could give to my parents. Ah, nice point. I like that. Is there any option available to me? I was told it was useless to appeal. I don't honestly know the answer, but I really don't see why they can stop how you file. And the fact that you've contacted CRA and they said, oh no, this makes no difference tax-wise, so you can't spread it. I don't believe it. File 3 returns. How can they possibly say to you, well, you earned income over a 3-year period. You're lawfully able to report it over a 3-year period. But because there's no difference in the taxes for us, Canada Revenue, thank you, I appreciate that. You can't file it over 3 years and use your disability credit over 3 years. I don't believe it. Now, that doesn't mean the person on the other end of the line at CRA had any disinclination to say that to you. But let me know what happens. I just don't believe it. We live in a self-reporting tax system. You're supposed to find out your own credits and your own deals and how much you're supposed to pay, and then you're supposed to voluntarily self-report it and pay it. How's that for freedom? So I just don't believe it. Go ahead and file 3. See what the heck they do.
Can I have one here if you wish?
Sure, go ahead.
What protections are there to prevent a Henson Trust trustee, such as not paying the beneficiary or taking the money for themselves?
That's a risk because, of course, the Henson Trust trustee has an absolute and unfettered discretion, and they can give nothing, no question. And they can't be held to account because even if they were to disperse some picayune amount of money every month, they're still exercising their discretion. And unless evil intent could be shown, and that's pretty tough, then there's no real recourse. So what this means is that when I meet with the parents, for example, I point this out. I have to point this out. It's an obvious conflict of interest in each case because, of course, the residue of the trust typically goes to the siblings, and one or more of the siblings are the trustees in most cases. So there's always this risk. And what I do is I explain this to the clients, and they look at each other, and then they nod, and they say, no. Mary will take care of Tom. There's no question. It's, there's not an issue. Or they look at each other and, well, maybe we should also name Sandra his cousin. Because if you had Mary plus Sandra jointly and severally, well, then either one could disperse money without limit. So it's an issue, no question. And I've only had this a few times. This is rare, because normally the parents make the right decisions. If they're hesitant about the child, they normally have an excellent understanding of the dimensions and dynamics of the children, who gets along with whom. I remember one where there were 5 kids, 3 boys, 2 girls, and the one boy had a seizure disorder and some cognitive disabilities and a 6 to 12 week psychotic cycle. And he couldn't bath to get himself, because of course he could have a seizure. And so we had the 4 others, which is lots of siblings, to be trustees, right? And it turned out that the sisters could get along fine, and the sisters could get along with the brothers fine, but the brothers couldn't get along with each other. So we had to structure it so that at the end of the day, we didn't wind up with the 2 boys as trustees until right at the end. But the girls could be, then the boys could replace one of the girls. And then ultimately they perceived it as not workable. Not so much that the boys were going to try to deprive their brother. It's just that they would, one would want to be more generous than the other, and they would fight, and I didn't want to do that. The other couple that I've had where the trustee was, in fact, evil. They had a black heart with a bottomless pit. And the parents did it anyway. They knew. It wasn't that they didn't know. They knew what was going to happen. But they did it anyway. Don't know why. Unfortunately, these weren't ones I did. These were ones that came to me afterwards. But it's very unfortunate. You got any other good ones?
Yeah, I have. Do parents generally leave a list of instructions for administering the Hanson Trust? Is this required or possible? And how much weight does it hold?
Yes, a standard part of the procedure. Looks like I'm getting to my limit here, guys. Is a letter of wishes. And the letter of wishes, we provide a very detailed memo to help clients with this. It's like a letter from beyond, all about the child, the beneficiary, what the parents would do if they were there, what they've always done, what the protocol and expenses are that are in the routine the child has now. Because of course, usually by that time, that's pretty well established. And what they aspired, the child, how they aspire to have the child do things. And it's interesting because after the parents are gone, it's not unusual to find the child develops, grows, flourishes. Now, it's not obviously that the parents withheld them back, but they have treated them as a child all their lives. And they've done what they thought was best. But sometimes to excessively protective. Sometimes also the beneficiary is not a bad person, but they've been allowed to get away with a lot. And it's not necessarily related to, whatever their disability happens to be. The people with disabilities are just like anybody else. So most of them are nice people. Some of them aren't. Some are jerks. And they just happen to have disabilities. So when you get situations where, the sibling says, well, I'm not having any of it, right? I'm not the trustee, not going to have their power of attorney, not doing it, don't start, not doing it. Mom, I'll help you. I'm here for you. I know dad's gone. I'll make sure you're treated well. And, got that part, not a problem. But for Bill, not a chance. And then one step away from that is tough love. I remember a client family just north of Guelph, and there were two sisters, two girls. And one girl had apparently cognitive disabilities, and she lived with the parents. And then her sister was a businesswoman. She lived in a town close by, and and the girl who lived with the parents, she, when she had a cold, she would wander around the house, blow her nose, throw it on the ground. Mom would pick it up. Well, you can see that's not good, right? But that's what they did. So when Mom and Dad were gone, the sister stepped in, moved her into the home, sold it, split the proceeds, and set her sister up in an apartment in another small town close to her, but not the same town, Didn't want to be too close. I think this is going to have to be the last question, Karen. And within months, that girl was great. She was going to crochet classes. She was living on her own, making her own food, going on to visit friends, going to church, spending time with her sister, being pleasant. Phenomenal transformation. She was no longer infantilized by her parents. And her sister was having none of it, right? She wasn't going to do it, right? Tough love. So it's always a very interesting transition for me, because of course, as part of the trust setup and planning and financial planning and future planning, you have to plan for the needs and desires of the trustee, of the beneficiary. And, it wouldn't be uncommon for their expectations to be unrealistic. Oh, well, you should just buy me another house, just like Mom and Dad's. Well, no. But it's very interesting to see how it shakes down and what the plan is for the beneficiary of the trust. And it's often a very positive process. A lot of times it's just a continuance of what there was. The child stays in the same apartment, they continue the same daily activities, they're working with the same organizations, the sister can continue to file for passport funding and nothing changes, which is good. But of course, if you have approximately 13% of the 365,000 people in ODSP still residing with family, that's about 45,000 people. When their parents pass on, a few can remain in the family home. It can happen, but it's rare. So where do they go? What's the new plan? That's a little more challenging, of course. So it's a question also of, when do you try to make that transition? Do you do it while the parents are alive, or do you just leave it all as it is and then have the other siblings, the trustees, now that there's more money, house has been sold, right? Half the proceeds or a quarter of the proceeds are in the trust. Now there's a bit of cash. What do we do now? It's usually a hopeful, positive process. It's very difficult and stressful. We find the child beneficiary, a lot of times, if they're living at home, the parent or the last surviving parent, the mother, is their only friend. Now they're gone. This is very hard. And then, of course, for the rest of the children, there's grieving, and there's all the arrangements for the funeral, and there's the selling of the family home, and all those things. So it's difficult. But, and there's no dress rehearsal for it. But it's all happening to everybody at some point, right? Okay, Karen, I think that's it. Do you see anything else that really, has to be answered?
Not at this moment. Diane and I are answering them privately as we're seeing them come in as well.
Oh, that's excellent, excellent.
And if anybody just wants to contact or email our office, then we can answer them further.
Well, I can shut up and Diane can do a few if you want.
I don't know if that's going to work, but she's helping me type here.
I don't know. Diane, do you want to verbally answer any questions or?
Verbally.
I'm just going through them here. Most of them are dealing with Henson trusts and tax implications. I think those are questions that require a lot more discussion. So I would just welcome people to contact our office and discuss this further.
That's true. Yeah, that's true. With these questions that have been posted here, I'll apologize to everyone. I appreciate these questions. I'm not sure how to make best use of them, whether to put them on an FAQ sheet. If you send your question in to Karen@kpopelaw.ca, we will endeavor to reply. If you go to the website and you send in the family evaluation, it'll allow us to know who we're talking to. And at the end of it, it says, tell us your story. So you could ask your questions there and we would certainly reply. Anybody who fills in one of these family evaluation forms, we will certainly reply. And if you have interesting questions, like, what questions do I need for a will? That's here. And if you want to download our Henson Trust booklet, that's here. And this is a chapter. Gotta stop. This is a chapter of a book that I contributed about 10 years ago. It's been updated a few years ago. It's written for financial advisors, but anyone's welcome to download it. And it touches on a whole lot of stuff. I don't think it has anything on guardianship, but these resources are all available. So we're down to 16 people, so I think it's time to say good night, God bless. Thanks for taking part, and feel free to contact us.